Welcome to the 19th meeting in 2025 of the Delegated Powers and Law Reform Committee. I'd like to remind everyone to please switch off or put to silent your mobile phones and other electronic devices. The first item of business is to decide whether to take items 5, 6, 7, 8, 9 and 10 in private. Is the committee content to take these items in private? Under agenda item number 2, we're considering instruments subject to the negative procedure. The committee asked questions in relation to all of these instruments with the Scottish Government. The full correspondence is published alongside the papers for this meeting. And the first instrument is SSI 2025-144, the Education Appeal Committee Procedures Scotland Amendment Regulations 2025. This instrument makes amendments to the Education Appeal Committee Procedures Scotland Regulations 1982, which govern school admission and exclusion appeal hearings in Scotland. The committee asked a question about the enabling powers, specifically why Section 28H5 of the Education Scotland Act 1980 was not cited. The Scottish Government acknowledged that Section 28H5 of the 1980 Act should have been cited as an enabling power, but it considers that its omission does not affect the validity of the instrument. Does the committee wish to draw the instrument to the attention of the Parliament on the general reporting ground for a failure to follow proper drafting practice in that Section 28H5 of the Education Scotland Act 1980 has not been cited as an enabling power in the preamble? The second instrument the committee asked questions on is SSI 2025-149, the Firefighters Pension Scheme Amendment Scotland Regulations 2025. The purpose of this instrument is to change the employee contribution rates by amending the Firefighters Pension Scheme Scotland Regulations 2015, SSI 2015-19. The committee asked whether the title of this instrument should in fact be the Firefighters Pension Scheme Scotland Amendment Regulations 2025. The Scottish Government agreed that this would be the most appropriate title. It regretted the departure from drafting convention, but considered that the meaning, understanding or effect of this instrument is not affected by the form of the title in this case. Does the committee wish to draw the instrument to the attention of the Parliament on the general reporting ground and respect that its title is not in line with drafting convention? The committee also asked questions on SSI 2025-152, the Teachers' Pension Scheme Scotland Amendment Regulations 2025. This instrument amends the eligibility criteria for membership of the Scottish Teachers' Pension Scheme from the 1st of August 2025 by amending the principal regulations which contain the scheme SSI 2014-292. The committee asked two questions on the instrument. The first was whether it had been intentional to include a definition of, and I quote, immediate before in Schedule 1, thus suggesting the definition applies in each place where, where it appears, which includes references in both the new provisions inserted by this instrument and in existing provisions. The Scottish Government confirmed that the intention had been for it to apply only to the new provisions. However, it considers that in the context of the other 13 provisions, the new definition is inoperative and therefore is of no effect. The second question relates to paragraph 16(1)(d) of Schedule 1. The committee asked the Scottish Government what the words, and I quote, this part of the scheme meant in the paragraph and whether its meaning is sufficiently clear. The Scottish Government confirmed that the paragraph is meant to have effect in relation to the scheme as a whole as established by the principal regulations, and the unintentional ambiguity is regretted. The Scottish Government intends to clarify both these issues in the next amending instrument. Does the committee wish to draw the instrument to the attention of the Parliament on the general reporting ground in that the definition of immediately before inserted into Schedule 1 of SSI 2014-292 by Regulation 3 of the instrument was intended to apply only in relation to that term where it appears in new paragraphs 15b, 15c and 15d, but has been applied to all instances where that term appears in Schedule 1, and that the reference to this part of the scheme in new paragraph 16(1)(d) of SSI 2014-292, inserted by Regulation 4C of the instrument, it should be a reference to the scheme as a whole. Does the does the committee wish to note that the Scottish Government has undertaken to clarify these points in the next amending instrument?
Yes.
Also under this agenda item, no points have been raised on SSI 2025-146. Is the committee content with this instrument?
Yes.
In relation to this instrument, does the committee wish to welcome that it fulfils a commitment by the Scottish Government to correct a drafting error in the Valuation Proposals Procedure Scotland Amendment Regulations 2024 SSI 2024-186? And does the committee wish to note that the Scottish Government intends to correct a minor cross-referencing error identified by the committee as soon as possible through a correction slip? Under agenda item number 3, we're considering an instrument not subject to any parliamentary procedure. No points have been raised on SSI 2025-157. Is the committee content with this instrument? Okay, we move on to agenda item number 4, and we're taking evidence from Graham Simpson MSP, the member in charge of the Scottish Parliament Recall and Removal of Members Bill. The member is accompanied by Katrina Lyle, a solicitor from the Legal Services at the Scottish Parliament, and I welcome you both to the meeting, and particularly welcome you back to the committee, even just for a short period of time, Mr Simpson. Obviously, formerly you sat in this chair in the last session, of course. So just as a reminder, you don't have to press any buttons, that will be undertaken for you. So move on to questions. So, Mr Simpson, it's quite rare to see an express power to legislatively sub-delegate in a bill. The committee is keenly interested in this because it is the potential to erode democratic accountability. It's one thing to give Scottish ministers the power to make regulations, but it's another to give Scottish ministers the power to give that power to a third party. And with that in mind, it would be helpful if you could provide the committee with some further context with regards to that proposal in the bill, and also is there a precedent that served as a model for section 21?
Okay. Well, thank you very much for your welcome, convener. It is good to be back. It's been a while. As you know, I enjoyed being convener of the committee and always found it a very valuable committee. It's probably one of the most valuable committees that there is in Parliament, and I'm not saying that to butter you all up so you'll give me an easier time. It's just the reality. If it's okay, convener, just by way of background, I thought it might be useful if Katrina was to set that out, and then I can respond more fully to your question, if that's okay. So.
Yep. Good morning, committee. Yeah, just to give some background as to why section 21 of the bill, which is the power to make regulations, is drafted in the way that it is. The similar provision in terms of the UK Act, the Recall of MPs Act 2015, is quite a broad power as well, but it's quite a long section in itself that sets out a number of lists of where the regulations may be made and what that might cover, but the list isn't exhaustive. The Recall of MPs Act 2015 also doesn't cover provisions that are in the Members' Bill in terms of the regional aspect. So there are differences. So whilst it has been policy to emulate as far as possible what is in the 2015 Act, it's not possible to do that sort of to the letter. So there are differences between the bill and the Act. And the Act was also drafted 10 years ago. So there are differences in drafting and in styles and such like. The reason that the provision is drafted, it's to emulate section 12 of the Scotland Act 1998. Now that section makes provision in terms of how the conduct of Scottish Parliament elections, and it was felt that there were a number of provisions in the bill that where those are being left to regulations such as campaign expenditure, where if the provision is made under section 12 of the Scotland Act 1998, there's a 2015 order that is then made under that that section of the Act, that those matters could be dealt with in a similar way to how Section 12 of the Scotland Act is set out. So that is why Section 21, it sort of emulates the style of the power under Section 12 of the Scotland Act to make further provision about Scottish parliamentary elections, and then that 2015 order sets out the further detail, and within that order there are powers to subdelegate to the Electoral Commission, but those powers are quite limited. They're administrative in nature, sort of filling in some of the detail where the Electoral Commission might have more of an expertise in running elections, managing elections. So that's the reason why.
Okay, thank you. I hope that's useful. But your question is essentially, is it appropriate for the government to confer powers on somebody else to make legislation? And I think this is an example of this committee doing its job, frankly, which is what I want. I want the committees dealing with this bill to be scrutinising it thoroughly and properly, and because it, inevitably, as it moves through the parliamentary process, I would want to see people coming up with good ideas to improve the bill. So I think you've landed on something that we ought to look at for stage 2. Now, between being invited back to the committee and being here today, I got in touch with the Electoral Commission, which could be a body that might be invited to make this subordinate legislation. And I just wanted to have their take on it, because I've been in contact with them about the bill, and will continue to be in contact with them about the bill. In fact, we might work on amendments to it at stage 2 and stage 3. So I just wanted to see what they thought about this particular provision. And I think they're pretty clear. In their response to me, they say, we wouldn't seek to take on the writing of secondary legislation, given our role as an independent statutory body accountable to the Scottish, Welsh and UK Parliaments. Drafting secondary legislation would raise policy questions which would be for the Scottish Parliament to decide. We would expect it would be for the Scottish Government ministers to write the secondary legislation, as is currently set out in section 21 of the bill as introduced, and we would expect to be consulted on the relevant draft legislation. So I think, given that that's their position, which is pretty clear, I think this is something that we probably should be looking at for stage 2.
Okay, no, that's very helpful. And certainly I think that particular information, if you could send that information on to the committee as well, please, in that reply, that'd be helpful. Thank you. Okay, Jeremy Balfour.
Thank you, Convener, and can I thank Mr Simpson for coming along. In the light of what you said, I don't have any further questions.
Okay, thank you. And Katie Clark.
Yes, welcome to the committee, and you state in your written response that you anticipate the powers to make subordinate legislation will be given to the Electoral Commission or the Electoral Management Board. Do you think that should be specified on the face of the bill? Because there's an argument at present the drafting of the bill allows powers to legislate to be given to any third party. I don't know if that's something that you've given any thought to or have any comment on.
Well, Ms Clark, thank you for the question, but I think what I've just read out perhaps supersedes the question. And in that I think that this is something that we ought to be perhaps reconsidering for stage 2. And I'm more than happy to work with the committee if you want to be involved in that, because we need to get this right. I want this bill. Obviously, I want it to proceed, but I want it to be right. And I realise that there are other areas of the bill that your committee are not looking at, where I can see that there could be areas where you know, there are questions to be answered, areas that could be improved on or changed. And within your committee's remit, this is an area that you would look at. So I would just invite you to consider the offer to work with me for stage 2.
So is it your position that you think that the Electoral Commission or the Electoral Management Board should have a role in the drafting, and you wouldn't necessarily be opposed to the powers themselves and subordinate legislation being made by Scottish ministers? Would that be something, is that a fair reflection, or is that something that you're happy to consider and work on?
The position of the Electoral Commission is clear.
It's a start.
They don't want to draft subordinate legislation. They would like to be consulted on it. Their position is, and I have to respect that, that it is the government's job to do that. And I'm quite happy to respect that. And you would expect that to be their position, I think.
Yeah, so you're comfortable with consultation of the Electoral Commission, Electoral Management Board, or indeed other relevant bodies. Thank you very much.
Thank you.
Thank you very much. Yep, there we go. Yes, thanks very much. And my question was along the lines of what you've already answered, so I don't want to go into too rambly sort of an element, but your written response pointed out that the regulations made under the Recall of MPs Act 2015 created criminal offences, and that is of course correct. However, those regulations were made by UK ministers directly under powers from 2015 Act. So the committee is looking at section 21, which, you know, as you've already said, would give powers to unnamed third parties. I mean, the Electoral Commission and Electoral Management Board have been named. Any other third parties who may be involved here, or?
No, I'm not. No, I'm not aware of any.
You don't, you're not? Okay, no. Then that's fine. Therefore, what is the, what do you see as the requirement for the power to create criminal offences? I mean, what's the element about criminality coming into this that someone would be covered by?
Do you want to take that?
Sure. I mean, the delegated power memorandum sets out some level of detail in terms of where it's expected that criminal offences might occur in terms of the recall element, and where some of the level of detail isn't known at this point because a lot of the detail is being made under regulations. But there are provisions in the Recall of MPs Act to make provision for criminal offences, but it would never be the intent that it would be anyone other than the Scottish ministers that would be making that provision in terms of any subordinate legislation that would require to make provision for offences. So that would never be intended that would be another third party. Under section 21 of the bill, it's the Scottish ministers may by regulations, make any of these provisions for the purposes of the conduct of the recall petition process. So the scope of it is limited in terms of it is just with regards to recall the conduct of the polls, and that section 21(2) then sets out that for the avoidance of doubt, those regulations that are made by Scottish ministers may do any of the following in terms of 21(2)(a), B or C. But it's certainly not the intent that a power to subdelegate to somebody else, an unknown person, for the purposes of creating a criminal offence.
No, and that's perfectly clear, and thank you both very much indeed for that. I'm just wondering about where you move from breach of regulations which are established to being acting in a criminal nature sort of thing, which seems to take it to a very different level altogether, so That's really what I'm thinking about. Does that make any sense at all? Well, I mean, you know, if someone is elected, which is a very important position, and etc., but they may not, you know, there may be elements of not turning up regularly enough or whatever sort of thing, as deemed. You can imagine that, yeah, that would be wrongful, and may breach your duties. But where does it move then to becoming criminal in doing that?
I think, Mr. Kidd, the power that you're talking about relates to the recall element of the bill,
Yes.
and not the non-attendance element
Well,
of the
that's
bill.
true. That's true. Yeah.
Which is entirely separate. I think the committee's, I presume, content with that.
Okay.
This just relates to the recall element.
Okay. Right. Well, that's fine then. Thank you very much.
Yes, thank you, and I'm very sympathetic to the creation of criminal offences. But do you agree that criminal offences should be created in primary legislation and not subordinate legislation? That, or would your view be that because it would go through a committee process, that would be acceptable? I wonder if that's something you thought about and explored.
I think my preference is that we leave it to subordinate legislation, possibly after a period of consultation by the government.
And would that be legislation that you would it be positive or negative? Would it be a what would the scrutiny process be, and what would Parliament's role be in the creation of those offences? And I know this is an issue you are very strong on in other arenas, so I'd be interested in your view, because I suspect in many situations you would prefer powers to be on the face of bills because there's a greater scrutiny element, and I just wonder if that's something that you've thought about in this context.
I mean, that's always my preference, but sometimes you can't do that. You know, you do have to trust ministers to do their job. Sometimes, Miss Clark, and yes, even I do that. My preference, it won't surprise you to hear, is always, if we can, that we apply the affirmative procedure rather than negative. The greatest level of parliamentary scrutiny possible.
Okay, so your preference would be the affirmative procedure in relation to the delegated
Yes.
subordinate legislation.
Yes.
Thank you.
Thank you.
Thank you, Convener. Good morning, Mr Simpson. Thank you for this. I think you've actually already answered this, so it's really just for clarity, considering the answers you've already given. It's the subordinate legislation in section 21 can amend primary legislation. But as you've already highlighted, bodies, third parties such as the Electoral Commission aren't actually wanting to get involved in that. Are you happy that because of their submission that primary legislation change is covered? And if not, would it be better to limit those powers? I think you've already answered it, but I just wanted to highlight that point on the record.
I think I have answered it.
Yeah.
Yes.
That's fine. Thank you.
Thank you. Colleagues, any further questions?
Nope.
No. I just got one for Mr Simpson. It's more of a policy and related question. So obviously the Act passed in the House of Commons in the UK Parliament. You're obviously bringing this bill forward for here for MSPs. When you were looking at, when you started working on it and looking at this in its infancy, did you consider expanding the bill to also include local authority councillors?
It's a radical idea, Convener. I hadn't considered it. No, that's the answer is I hadn't considered it. But if I'm to think it through, I think I would open a hornet's nest that we might not want to open. And I would imagine COSLA would have a pretty strong view were we to suggest having a power of recall for councillors, a power that I don't think exists anywhere else in the UK. So I think if you, Convener, were to suggest a stage 2 amendment along those lines, I think I would probably be resisting it.
No, it's certainly...
Convener, you seem to have sparked something off in the committee.
I'll bring you... Right. So certainly just with regards to also the bill, it was something that just struck me when I looked at your bill with regards to would that actually be would it be feasible for it to be included in the bill? And I assume it wouldn't be anyway, because the bill is tightly drawn, focused on parliamentarians. So I wouldn't imagine any amendments would be successful. But I just thought I'll take the opportunity just to ask the question since you were sitting in front of us this morning.
Yeah, absolutely. I do think it will be out of scope because it relates just to MSPs. Yeah. But it's an interesting idea, Convener, one that I probably wouldn't agree with, though.
I didn't say I did agree with it. I just thought I'd pose the question. Right. That's obviously what we're here to do. Yeah. Okay, any other... Yes, Jeremy?
Yeah, I mean, I think actually that, sorry to jump on, but I think that power actually already does exist within law. But if a local councillor doesn't appear at a full council meeting for 6 months, they are automatically struck off, and they have to have a by-election. So that power does exist, and which is an interesting model of saying when you come that there's a 6-month rule there for local government. And in fact, just to show how nerdy I am, Edinburgh City Council has had to pass a special motion last month because one councillor hadn't attended for 5 months and was about to be, but you can give special reasons for not doing it. So it might be worth looking at the local government powers that are already there.
Well, the convener was asking about the power of recall and whether I'd considered extending the power of recall to local councillors. One element of this bill, Mr Balfour, indeed relates to the matter that you've just raised. It was actually the idea that I first started with, and it's that question around non-attendance, which, as you rightly point out, having been a local councillor, and I have too, there is in law a provision where if a councillor doesn't attend for 6 months, they can be removed. That is a feature of my bill, and it would relate to MSPs, because as you also know, it's entirely possible for an MSP not to come to work, not to do the job that's expected of them by the public. So that is a key feature of this bill. I hope that reassures you.
I am very reassured.
Okay, Mr Simpson, thank you very much. Any further questions? No. Okay, thank you very much, Mr Simpson and Ms Lyle, for your evidence this morning. The committee may follow up in writing with any additional questions stemming from the session. So with that, thank you once again, and this now concludes the public part of the meeting, and I'll move the committee into private.